Hey folks, it's Spitz from Pixels and Pills, and it's my pleasure to have Darshan Kulkarni, healthcare regulatory and technology expert, with me here today. Just
Thank you.
as a little footnote to our conversation, please don't take anything we say as legal or regulatory advice. It's just two guys riffing off some exciting new developments within the pharmaceutical marketing and communications world. Thanks for joining me today.
Thank you for having me.
One issue. Oh, it's my pleasure. As a pharmaceutical marketer, just about everything we do is essentially defined by two types of conversation and communication. That which is on label, within the mandate of the FDA's designation for what a drug can do,
hmm
and everything else which is ostensibly off label, which is
hmm
outside the mandate of the FDA pertaining to a particular drug or treatment option.
hmm
Now, a recent ruling by New York Second Court seems to have disrupted the status quo in a fairly significant way. Can you give us a quick overview of this landmark case, and then perhaps we can discuss some of the implications, potential implications for pharmaceutical marketing?
Absolutely. Thanks for having me again. So Spitz, the story is that there was a sales rep called Alfred Coronia, well, named Alfred Coronia, and he went with a doctor Peter Gleason, and he was promoting a drug called Xyrem. He went to a doctor's office and talked about the drug. Dr. Peter Gleason talked about the drug, and they landed up talking about off-label indications of the drug. Um, Turns out that he was in the middle of a sting operation, and Peter Gleason and Alfred Coronia were both prosecuted. Dr. Peter Gleason lost his license, died, and then the state of Florida went after his license again. On the other hand, Alfred Coronia, um, luckily for him, survived, and he actually recently won the court case, and the Second Circuit Court of Appeals basically came out and said that the pharmaceutical industry, as long as the information they're providing is both truthful and not misleading, um, you cannot have content-based restrictions around their conversations. So
Now,
that's the
this, I
quick
mean,
summary.
to my ears as a pharmaceutical marketer who's been in the business for many years now, this is very surprising. So, what did the government use to substantiate Coronia's innocence?
Well, you mean the government was trying to prove that he wasn't innocent? What do you mean by use to substantiate his
No,
innocence?
no, but I mean, basically, it came down to a First Amendment
Right?
rights issue, right? A freedom of speech issue.
Sure. So what did Coronia say?
So,
Why?
so
On what basis
how
did
does
he
that
say?
pertain?
Okay.
Yeah. So
Okay.
what's the relationship between my First Amendment rights as a citizen of the United States of America
Uh-huh.
and then ostensibly marketing a treatment option for a pharmaceutical company which is controlled by the FDA?
So let's sort of recognize, as we all know, that drugs are controlled poisons. That's really what drugs are. That's what I, as a pharmacist, would say. That's what anyone else would say. So the FDA has a vested interest in their mandate to make sure that the health and welfare of patients is being preserved. So that's why the FDA requires that that only truthful and not misleading information be put out, and that that information be proven to the FDA before it can be disseminated. Um, in the course of um, the Alfred Coronia case, the discussion focused around off-label. The idea was Alfred Coronia neither gave any information that was false nor was it misleading. Additionally, the information, the indication he talked about, I believe in this case, turned out to be approved by the FDA a few years later. So the FDA agreed with the information he provided. They just didn't agree with the timing of the information he provided. So the courts looked at all this information, and their argument was that um, the restriction is not around the restriction around content is not something that the Constitution supports, and a restriction around content was therefore unconstitutional. It goes into a whole legal analysis, and it talks about speech-based restrictions and free speech depending on on what type of discussions being had, but the real end point is exactly what we're facing right now. Off-label speech cannot be restricted if it is truthful and not misleading. This is the holding of just the Second Circuit. It does not necessarily apply across the world or across the country.
But aren't we really talking about context here? I mean, the pharmaceutical industry already employs healthcare professionals, within particular disease states, authorities within their field who do a lot of research and share a lot of off-label information for educational and research purposes. But in a sense, aren't we crying fire in a crowded theater, in a sense, when you enable, let's say, a sales rep to have these off-label conversations, even if they are truthful, non-misleading, and scientifically accurate, at the point of sale, point of care, in a
why is that necessarily? Office. Why is that shouting fire in a crowded theater?
Well, from the point of view that you said earlier, that the FDA's responsibility is to monitor and maintain controlled poisons. So, where do we draw the line between a helpful conversation about treatment options on the one hand, and the FDA's ability to control these conversations within the structure that they've created for pharmaceutical and device messaging?
Well, the question you're trying to answer is the same question that the FDA is trying to answer right now. On one hand, you're absolutely correct. The courts don't like restricting free speech, and the FDA's mandate must be respected. However, if that mandate results in a restriction on free speech, the courts aren't happy with it. In fact, this exact argument was used a few days later in the Scott Harkinen case, and this whole free speech argument was used. However, the free speech argument failed in that case in the Ninth Circuit because it was deemed to be false and misleading. So the argument that you cannot give out information, you cannot give out truthful information, and it restricts free speech, that argument doesn't hold much water if it lands up being that the information you're providing is not accurate. So in the Scott Harkinen case, and it's a slightly different fact pattern, the CEO gave out information that was not completely accurate, and he tried defending it because he was an MD, and he said he had the right to give out that information. The courts basically said it turned out to be misleading, and the FDA is allowed to regulate that information. So the courts have basically drawn this line that you can't prevent the speech from occurring. You are allowed to prosecute false and misleading speech if it happens. So it has to happen after the fact. It can't necessarily happen before.
Okay, but let's say all this is valid and becomes a best practice. Where do you draw the line between these types of communications across all the channels that are available to pharmaceutical marketers? Here we're talking about a sales rep having a conversation with a physician at the point of care about off-label use of a drug in a casual kind of conversational manner. Could this potentially dovetail in expanding that right to the company to begin marketing this drug outside of what would be considered the boundary of labeled information?
I think if I understand the question you're asking correctly, your question is it form specific? Can this only be done in the context of a sales rep? And the FDA has always said that they are form agnostic, or they are channel agnostic.
Exactly.
So the argument that, the sales reps are allowed to do one thing, but on Twitter you have to act differently, well, that argument just simply doesn't hold. In fact, the FDA, I opine, and I could be wrong about this, but the FDA has held off on making several, as we all know, we've been waiting for several years on social media guidances. They finally put out a guidance last year, i.e. the unsolicited request for off-label information, and that guidance, if the Alfred Coronia case holds, may need to be updated. So the FDA has been holding off, and now the implications of this Coronia case will necessarily apply to all the future guidances that the FDA does still have to put out.
Absolutely, and as The flip side of the crying fire in a crowded theater is that some of these off-label conversations, and many of them, could actually be in the best interest of the patient or even public health. As we know, the FDA is overtaxed. Getting approvals for many of these drugs is a laborious, time-consuming process, and there are many patients who are desperate for medications that ostensibly have been proven in clinical trials and studies that weren't part of those that led to the labeling of a particular drug. So there's obviously benefit to some of this. The only question then becomes really, where do you draw the line? And how could you ultimately enable the FDA to enforce what's considered label communications in this kind of environment where this line is shifting so radically?
And I don't think the FDA knows yet, and the FDA has decided to play it cool for this moment. As you point out, in many cases, the FDA goes out and has said this outright. They say that we do not control the practice of medicine. Doctors are free to prescribe the way they deem appropriate. They are governed primarily by state boards of medicine. On the other hand, the FDA looks at what pharmaceutical companies and medical device companies, etc., are saying. However, now that this path is changing, they do have to consider the impact. And one has to consider if pharmaceutical companies or life sciences companies are the best holders of information, if they have the most information, does it make sense to restrict, in the best interest of the patients, does it make sense to restrict the information itself? So a doctor might be aware of 2 studies. If the life sciences company has 50, does it not have a responsibility to give those additional 50 studies out to the doctors? According to the FDA, no. According to the Second Circuit, maybe it is allowed to give that information out. The Second Circuit doesn't opine on the responsibility portion of it. Those discussions are being had right now. The impact of the Second Circuit is being felt right now. We'll find out where it takes us.
Well, it's very, very intriguing because, again, it's almost taken for granted that line is drawn between the off-label and on-label discussion. This case seems to blur that line a little bit. Obviously, the pharmaceutical companies are excited about the prospect of being able to message and discuss their treatment options in a broader sense to physicians. And of course, there are advocacy organizations and patient-centric groups that are a little bit panicky by this ruling, fearing the opportunism that some of that freedom might entail for some of the larger companies. I guess the end result.
We should consider the fact that the bad ad program will help with this. Do you know what the bad ad program is, Mike?
Yeah, absolutely, absolutely. But
just as a recap, though, for the people who don't.
Yeah.
The bad ad program is where the FDA effectively deputizes healthcare providers to go out there and complain about sales reps or other methodology which is used to communicate false and misleading information. So if the bad ad program is so successful, and the FDA actually talks about how successful it is, the FDA technically has an enforcement police force of hundreds of thousands of people, i.e. doctors, pharmacists, nurses, and other healthcare providers who can help the FDA police this type of process.
Yeah, but post-Coronia ruling, it becomes a little bit more difficult to substantiate what's considered false and misleading. I mean, which clinical study are you citing, and what do we consider authoritative at this point when I
don't think that line has shifted as much, actually. So no one's really arguing whether we're still discussing what is deemed to be false and misleading. I agree with you. However, a simple study from Belgium will not be a sub-analysis of a study from Belgium would not be deemed to be adequate information. So that's what happened in the Scott Harkinen case. Right. In that case, he used a sub-analysis, and it turns out he tried to hide it and tried to mischaracterize it. And when he was questioned on it, he said he basically, from what I understand, he allowed that to happen anyways. So the argument that, oh, I'm allowed to make an independent analysis and we believe this is truthful is not good enough. It has to hold up to independent standards of truthful and not misleading.
Okay. Well, we do have that to stand on. And again, this could be potentially hugely beneficial to patients as well, because physicians and even them are receiving additional information with regard to treatment options that could very well be useful to them.
Absolutely.
Yeah. Thanks, folks. It's Spitz with Pixels and Pills. My pleasure to have Darshan with us today, and we'll see where this case lands the industry. Truly a landmark decision.
Thank you again, Spitz.